So by doing this, what is the impact that we have on your communities? Well, and the people within your communities. We are in the business of saving wealth and promoting efficiency. There's not a single court system that we are involved in that we don't help clean up their docket by ensuring that what would be pro se litigants, respondents, petitioners, whatever the case may be, instead of being pro se, where they may file a dozen meaningless motions that have no basis in the law, they're able to have an attorney represent them and guide them through the process. This is most often useful and beneficial in your local communities through the probate court. Go call your probate clerks at your local town halls and ask, what does an intestate will administration look like? And they will tell you that it takes somewhere between 1 and 2 years for them to resolve the issues and close on an intestate administration. Now, if they have a lawyer, you can speed that up. But if the person who is about to die is able to meet a lawyer and devise a will before they pass on, they can shorten that to 6 months. You've now shortened the docket period by a lot, and you can see how it's a snowballing effect. So that's the impact we have on a local scale. I want to open myself up to the committee because I will tell you that I've seen it all. I have one foot inside the medical legal partnership, so I'm aware of what we do there, and I am the main attorney at our Warwick office. People will often ask what my caseload is like. At the Warwick office, I see on a yearly basis approximately 1,000 people come through our door that are clients. Now, I'm not going to lie and tell you that all 1,000 are serviced directly by me, but at least half of them are. At the Medical Legal Partnership, we have something approaching 300 people per year. I don't see all those people either, but at least a third of those people there are serviced directly by me. The rest of the caseload there is handled by the other attorneys, often volunteer attorneys who draw no salary, and by the case management system we have through involvement with the law school providing us dedicated interns looking for their pro bono service hours. I've consulted terminally ill patients and helped them devise estate plans so they could pass with dignity and grace. I have succeeded in court for clients who at the end, with tears in their eyes, shake my hand and say, "Thank you, you've saved my life." The impact our office has on such clients cannot be understated, but what must not be forgotten is the impact they have on us. They have shaped the way how I will practice law, the way how I will look at public service forever. I don't know how long I will be at the Rhode Island Center for Law and Public Policy. I hope it's many years to come. But even if I were to stop my service there tomorrow, I'll remember the importance that public service has on the society and on the people that you serve. It's important not to lose sight of that. The one thing that was missing in the introduction that our president gave was the story of how it was founded. It was founded in 2008 when he told his wife that he wanted to start doing pro bono legal work. And I'm surprised he omitted this story. And she kind of said, "Yeah, well, what are you going to do now?" And he said, "Well, I want to help people, and it means I probably won't get paid." She said, "Well, how's that any different than what you're doing now?"
You can see why I omitted it.
The important part to the takeaway there is this. Our president does not draw a salary. He works at the agency, the Rhode Island Center for Law and Public Policy, works many hours. He does not draw a salary for his time. That inspired me as a young starting legal professional that when I was first hired, I was hired as a part-time attorney, but I worked a full-time caseload. So I was working 50 hours a week, even though I was only being paid for 20. And I did this gladly. And you do this gladly because you see the impact that it has on the people that you are serving. I will close with only two thoughts, and that is this. After testifying last month before the Senate, it was asked of me once by somebody following that testimony that in the language of this bill, one is we are asking for a waiver that our organization will not have to pay the court fees. And they were like, well, they were skeptical on what impact that might have on the state. And I just laughed. The reason why I laughed is in the 3 years that I've been practicing law there, offhand, I can only think of maybe 2 or 3 clients that we have ever represented who have not qualified for the fee waiver from the court case. In any event, even if my memory is not accurate, it cannot be more than a handful, 5 or 6 tops, over the 3-year period that have clients who come through our office who have not been found to be qualified for the fee waiver through the courts currently in place. And in closing now, I want to close with an example of the type of work we do. It's a short example. The example is a story of a 98-year-old resident, and she came to us. And she and her husband had provided the funds for her daughter to buy a house. And they did so because the house had an in-law apartment. So the house would be the daughter's, but she and her husband would live in the in-law apartment. After a few years, her husband died, the daughter married. We have reason to suspect that the daughter's husband was possibly involved in domestic abuse, but that would go beyond the scope of what we're here to talk about today. In any event, the son-in-law grew agitated with the 98-year-old mother, mind you, the person who had made it possible to even buy this house, and he sought to evict her at 98 years of age. So she came to us, and we worked. We worked with her, and we worked with threatening court injunctions, police departments, and we were able to prevent that eviction. It took about a year and a half, but in the end, she was able to pass with dignity and grace without being made homeless by her, what I can only imagine is a monster of a son-in-law. So that's the type of work that we do on a day-to-day basis. I could occupy 2 hours of your time giving you more stories, but clearly no one has any interest in that. So I will just close by telling you that there's no stronger words can I emphasize and urge you that the passage of these 2 bills will better our state, it'll better your communities, it will better everyone all around. So we would like to urge you to pass these bills. If you have any questions, I'm welcome to take them. Thank you.
Representative Walsh.
We are also talking about 7842 as well.
That's correct.
Now, I'm noticing the fees here are not $10 in district court. The fee increase is $5 in district court. Superior Court is a $10 increase.
That's correct.
So why is district court only $5?
The disparity is that the fee increase that we're asking for should be in relation to the current fee that is already existing for the filing fees. District court is supposed to be a more approachable court for people to first reach, so you wouldn't want to increase it $10 when it's currently, I believe, a $60 filing fee in district court. Or is it $55? $55 right now. So a $10 increase in district court would represent basically a 20% increase of the fees, whereas $120 in superior or family court, a $10 increase is only 1/12.